So now, Barrister Emmanuel, it's your turn. So can you
Take a
introduce
minute.
yourself again, please?
Hi, my name is Emmanuel Akuma. I'm a lawyer. I've been a lawyer for about 7 years now.
Okay, so
Yeah.
where are you located?
Well, I live and practice in Abuja. I do my law business, quote and unquote, in Abuja here. So that's where I'm at.
Okay, so you said you've been a lawyer for about
Yes, give or
seven
take.
years now.
Yes.
So why do I, if I, why do a typical person, a novice, why should a novice, somebody like me, need a lawyer?
Um, well, I think the average Nigerian believes that he needs a lawyer when he has a case, but that is generally not so. I do not ascribe to that thought process. So, take for example, a few moments ago, you had shown the secondary school construction going on in Igbere. So typically there is what they call construction contracts and the rest, which specify basically the entirety of the brief of the architects, the builders, and the rest of them. So if you even want to engage in such a project, it's usually advisable for you to engage a lawyer who would draft out basically the terms of engagement for you, the sponsor, and for even the architect who is doing the job for you. So you need a lawyer basically for just about anything you want to do. Even when you go into the supermarket to get an item, you follow some rules and some even legal principles in the course of purchasing an item without you even knowing that. So when let's say you buy the item and it now becomes defective, you are now looking towards engaging a lawyer, and it's a lawyer who will tell you, oh, this is what has happened and this is how you would go about it. So you basically need a lawyer for everything you intend to do. Even as little tax as buying a car, sometimes you might need an agreement for that. You live in America, you might need to finance your agreement. Some of those terms are not, they might be English, but if English were that simple, then people like us would not be in business.
Okay, so the writing has implications. That's what you're saying.
No, yeah, everything, because like sometimes you see people when they are speaking, they say will, shall, may, would. When the chips are down, those words mean totally different things. But when you're having a simple conversation, they can be used interchangeably. But once it's on black and white and a dispute has arisen, you see that shall has a totally different, and words as simple as and or have extremely complex meanings. Shall, will, may, they become extremely complex. So it's essential that you have somebody, a lawyer, advising you when it comes to those things and when you want to take some certain steps.
Okay, so now if I have a matter
Hello?
right now,
Yeah.
I read over the newspapers and magazines. They talk about Supreme Court, Court of Appeal, and stuff like that. So if I have a case right now, so where
Yeah.
am I supposed to start?
I know the first step ordinarily is recognizing the fact that you have a problem. Then you engage a lawyer because it's the duty of your lawyer to ascertain the entire gamut of your case and provide the best, pathway for you to seek legal redress. So you can't get up, you as an ordinary citizen, you can't get up and go and file your matter at the Supreme Court, but you have because you're not a lawyer. So you acknowledge the fact that, oh, I have a problem, and you go and engage a legal practitioner.
Okay, good. Now the legal practitioner starts where in terms of handling the case.
So, say again, I didn't get you.
So where does the legal practitioner, the lawyer, start in terms of handling a typical case? What level?
Oh, like the first step is okay. So the first step is when you acknowledge that you have a problem, you engage the legal practitioner. You brief him. Then you would consult him. Basically, the consultation involves, oh, I have this. Okay, take for example, I had used the supermarket illustration. I went, I bought a bottle of juice, and while I was drinking that juice, I saw some debris. I didn't know I had ingested those debris. I ended up spending a month in the hospital. So the lawyer there would now look at it and basically falls into this illustration. Basically, it's negligence. The manufacturers of that bottle of juice owes you a duty of care to ensure that it is safe and okay for consumption. So they've breached that duty of care by allowing those debris to find its way into the bottle of juice. So when you consult with your lawyer, he analyzes your problem. He tells you a solution. Then, when he advises you, that's basically the first stage. You can decide to go away with the advice, satisfied, because sometimes some things might happen to you. And after you've consulted the lawyer, you come to see that there is little or no legal redress available for you. So when you say have a legal redress, the lawyer will now decide as to what ways to pursue it. So sometimes all the lawyer might need to do is to write a letter to the errant party, and they comply. Sometimes they might need to end up in court. And if, let's say, there has been an agreement, a party has breached it, your lawyer might need to go through that agreement to see if there is what we refer to as a dispute resolution clause as to how parties can resolve their disputes before even advising you on how you could go about seeking your redress.
Okay, so there are
Yeah.
other processes that can be used to resolve issues apart from going to court. So now, when it
Oh
comes
yeah. Oh
to
yes.
going to
Typically,
court, so what's the first?
we advise. I for one, I see going to court as the last measure, because I have come to really understand in this part of the world that you cannot take somebody to court and still be friends with the person. So, you try as much as possible, peaceful resolution, amicable settlement, or you get move ground a bit before it gets to the court, because the wheels of justice might grind slowly, but it grinds slowly and surely. And when it comes to a halt, most of the time it's usually catastrophic for a party who, it's against. Yes.
Okay, so now, so what level of court do you start in a typical case?
No, the what determines the court you go to in a typical case is the issues involved. So take for example, if it's a regular landlord and tenancy matter in a place like Abuja, and say your rent is a million, between 1 million, between 5 million under, it goes to the magistrate court. So when you're suing a government agency, you want to sue FIRS, the Nigerian police for whatever reason, you go to the federal high court. So when two states are battling, they go to the Supreme Court.
So if, for example, Abia State is in conflict with, let's say, Imo State.
Oh yeah, they're going to the Supreme Court.
They're going to Supreme Court straight.
Great, yes.
To file the matter.
Yes.
Okay.
That's what the Constitution provides for. Yes.
Okay. So now you are saying that the level of court you are going to, or the type of court you are going to, depends on the case.
Oh yes, it depends on the dispute involved. Yes.
It's a political case right now, like an election is held and somebody is declared winner, and obviously another person lost, and then the person who lost wants to go to court. So what level of court is that person going to start with?
Okay, so election petitions typically are sui generis. They are entirely unique. They are peculiar. So the Constitution and even the Electoral Act provides for what is described as the election petition tribunals. So the election tribunals are the equivalent to the High Court. The High Court of a state, the Federal High Court. They all have the same jurisdiction when you look at it legally speaking. So yeah, petitioner would head towards the High Court, the election tribunal, and file an election petition contesting the electoral process or the electoral results, whatever the case may be.
And after that, after the tribunal, where else do they go?
Oh, it depends on the outcome of the tribunal. Like if you do not like the outcome as a petitioner, it's only natural for you to want to go higher. So from there, they could head up to the Court of Appeal or the Supreme Court.
So is it possible to jump the Court of Appeal and go straight to the Supreme Court?
No, you can't. You can't, because the Supreme Court will kick you out too.
Okay, so if you don't like the outcome of the verdict by the election tribunal, so the next step would be going to Court of Appeal.
Oh yeah, you go to Court of Appeal, yes.
Okay, and after the Court of Appeal, the next level will be the Supreme Court.
Supreme Court, yes.
So, and any matter that gets to the Supreme Court, so what's next?
Oh no, when you can still go further, you go to God after the Supreme Court.
Okay.
Yes.
Okay. All right. So, typically, what do I? So, if it's a simple case, like a criminal case, like let's say maybe political. I don't even know how to say it. You know, something that requires, let's say, EFCC. So, what's their first level of court that they go to?
Oh, the EFCC typically goes to the High Court.
Okay.
To the High Court. So if the matter is, say, if they did the investigation in Abia State, you know, or the offense was committed in Abia State, they might go to the High Court in Abia State or even the Federal High Court in Abia State. But the first step for most financial crimes, you know, criminal proceedings involving financial crimes is the High Court. So it could be the Federal High Court, it could be a State High Court. So it's usually the High Court.
What's the difference between the two? You said Federal High Court and State High Court. So what's the difference between?
Okay, so it's just basically constitutional provisions. You know, just constitutional provisions, and I think that is like explaining that now is beyond the ambit of this scope. But how do I put it for ease of understanding? Okay, so take for example, like I had said earlier, if you have a matter involving a federal agency, you go to the Federal High Court.
Mm-hmm.
You know, you go to the Federal High Court. So Section 251 of the 1999 Constitution lists out, you know, close to like 36, you know, items that if it's involved in a particular dispute that would require you going to the Federal High Court. Say another one I think is aviation. You know, so if there's a dispute involving, let's say, that entails aviation or something of that nature, I'm sure you're ending up at the Federal Court to go to is the Federal High Court. So it's the issues involved.
Hold on.
Okay.
I don't know where I'm getting this background noise. Hold on, please. I don't know where I'm getting this background noise. Okay, please continue.
Okay. So as I was saying, yeah, it's the dispute basically that will determine the court you would go to. So, like I said, the Constitution in Section 251 lists out certain items that would be involved in a dispute that would warrant you going to the Federal High Court. So, I think one of them is aviation. But generally speaking, when you have a dispute involving a federal agency, Federal Inland Revenue Service, what are the names of all these? Federal Housing Authority, the NNPC, the CBN, you know, you go to the Federal High Court. That is the court that has the jurisdiction to hear the matter. But constitutionally speaking, the State High Court and the Federal High Court and also the National Industrial Court are on equal footing constitutionally.
Okay, so now I have heard of this word, Senior Advocate of Nigeria. So, and what does that mean?
Oh, yeah.
And how does someone get to that?
Oh, so I think, okay, so a Senior Advocate of Nigeria is somebody who's in Nigeria. So he has basically put in the hours, he has distinguished himself in all forms of, basically in legal practice generally. He's, you know, a gentleman par excellence, and he's somebody to be admired in the legal profession. So yeah, that's basically a Senior Advocate of Nigeria. You've reached the top. You are at the top.
So who assigns that title, or how is it assigned?
Okay, so there is a committee that looks into it, you know, to determine if an applicant is worthy. So that committee is called the LPPC, Legal Practitioners Privileges Committee. So they are the ones who are in charge, and they make the rules for admission as a senior advocate of Nigeria. I know one of the rules, at least you ought to be a lawyer for a minimum of 10 years, but there are other requirements. You ought to have a certain number of cases, which contested cases at the High Court, contested cases at the Court of Appeal, contested cases at the Supreme Court. So you need to have, I think at the High Court, you need to have up to 20, Court of Appeal, I think 6 or 8, then the Supreme Court around 5, thereabout. So it's quite a lot. To get those, you've devoted your life to law practice and everything that concerns the practice of law, basically. Yeah.
Now for those cases to be counted, is it required that a particular lawyer, for example, would you be the one that files a case that has to be heard at Supreme Court for it to be counted, or is it a case that a lawyer joins, even if the lawyer is not the one who filed the case? So how does that work for it to be counted in your favor?
Okay, it's usually long and tedious. So let me give you a typical illustration of how it works at the appellate level. When I say appellate level, Court of Appeal and Supreme Court. Mm-hmm. So if you're filing an appeal, you start by filing what we regard as the notice of appeal. So if you want a matter to count for you when you are running for the senior advocate, you ought to have signed the notice of appeal. Then you ought to sign what we call your brief of arguments. Then you also have to go to court to adopt the said briefs of argument for it to count for you.
Okay.
So I think that's the way it works. That's the way it works.
Is it one lawyer that's the way it works? Can it be signed by more than one lawyer?
No, it's one lawyer that signs the document.
Is it represented by the chamber of the lawyer, or just by that particular person with a maybe MBA membership ID? I'm trying to figure out something out.
Oh, we call that enrollment number.
Okay, enrollment number, yes.
Yeah, we call it an enrollment number.
So, for example, a chamber can sign and it covers all the lawyers there, or a particular lawyer has to use the enrollment number to sign for it to count?
So a chambers can't sign a document, but you as a person, say you, for example, now, if you have a legal problem, you can engage a chambers, you can engage, a law firm. Mm-hmm. So a law firm can't sign a document, but that law firm has lawyers that work for them. So it's those lawyers, one of those lawyers that can sign the document. So take, for example, in our office, there are some cases we do. You see that around at the end of the day, like 6-7 lawyers end up putting their contributions on a particular appeal, because most of the time appeals are usually voluminous. You could get what we describe as a record of proceedings. Basically everything that happened at, say, the High Court, it comes in 2,000, 3,000 pages documents. So basically everybody is putting in a shift on that work, and in the course of doing the brief. So what we do is everybody who has worked, who has contributed a quota to that work, their name appears. Then at the end of the day, somebody signs it, basically, and goes to file at the Supreme Court. Most of the time, the most senior in the office, or the person who put in the most effort in the work.
So there's one more thing I want to find out. A lot of times people say breach of contract. So, So what is a contract generally, and what types of contracts are out there?
So a contract is as simple as, let me start this way. For you to have a valid contract, there has to be what we describe as offer, acceptance, transfer of consideration. Those are the 3 elements of a valid contract. Offer basically lists use this illustration. Um, you have this book, and I offer to buy it from you for 20 naira. That's an offer to buy your stuff. Then you accept, okay, give me your 20 naira and take my book. You have accepted. Then transfer of consideration is money, or money's worth, or money's equivalent. So transfer of consideration, you now take your 20 naira and give the person. So there is a breach of contract when, say, take for example, you give that person the 20 naira and he refuses to give you the book. That becomes a breach of contract. So when you look at it at its simplest, form, that's a breach of contract. There are more complex ones when you see in, multi.
So contract doesn't really have to be written down. Is that what you're saying?
Oh, no, it doesn't. It doesn't. We engage, like I told you, when you move into a supermarket, you move between the law of contract, sale of goods, even at times law of agency, just to buy an item in a supermarket. So it mustn't always be written. An oral contract is binding. But the problem with having oral contracts is witnesses. Take for example now this illustration with the book. If somebody is not there, it's easier for the other party to resile and claim that it did not happen or that there was no existing contract. So that's why it's advisable to, when it gets to very complex issues, to write it down, because black and white doesn't lie. You cannot remove or add to black and white, what's on the paper.
Okay. So
Yes.
I get it. Anyway, time now is exactly 2:00, and it should be about 7 p.m. Nigeria. So I thank you, ladies and gentlemen, for honoring this invitation to share in this program. Mr. Wisdom, you came late, so we ran out of time. So we'll have to address your matter next time. Okay. So for ladies and gentlemen who are still here, we really thank you. We really appreciate you. So if we still have follow-up questions on what you informed us about, we will not hesitate to contact you. But for now, we thank you all for honoring our invitation. And I believe the audience out there, they are going to benefit from your wealth of experience and wealth of knowledge, information that you have shared so far. So once again, thank you. Thank you all.
Thank you.
So the program is over.